Mr. Dunn, good morning.
Good morning, members of the court. May it please the court, my name is Lee Dunn, and I represent the appellant, Dr. Birudavol. This is a very document-rich case. There's an awful lot of paper involved in this case, but I believe that the case comes down to three documents: the single justice's order of October 17, 2005, the credibility determinations of December 7, 2005, and the appellant's renewed motion for judgment on the pleadings of January 27, 2006. I did not repeat that document in my brief. I just referred the court to it because it was in the administrative record. But that sets out 20 pages of points where the credibility determinations were wrong. And by that I mean there is conflicting evidence, and the conflicting evidence is never even mentioned. This case has three issues. The first one, and the broader one, is does 30A exist or does it not exist? Does a licensed professional in this state have a right to expect that when he or she goes before an administrative magistrate that they're going to play by the rules? That's the first and the biggest point in this case. Number two is the sufficiency of these credibility determinations. Now, the single justice did not order credibility determinations to be made. His order remanded the case to the board and for actions consistent with his findings. The board said to the Division of Administrative Law Appeals, with which your allowance I'll refer to as DALA, come up with credibility determinations. So she did. But they're findings of fact with no citations to the record. She might as well have taken the sports page of the Boston Globe and written credibility determinations across the front and handed them in. Because if you go through it and go through the record, 5 days of hearings, there's not a single finding that is made by that administrative law judge which is supported in the record. There's no cites. That is an astounding thing when you think that someone is making a decision about the license, the ability of someone to practice medicine, or anything, law, architecture. There are no citations to the record. And third, the severity of the sanction. Now, the credibility determinations, in my estimation, were written in direct disregard of the single justice's order and the cases that we cited on our brief. All one needs to do is read Cohen, Morris, Herridge 1, and Herridge 2, and you see a pattern that this court has established. Namely, you can make your findings, but you've got to at least consider the testimony and the evidence that runs counter to those findings, and you have to say why you believed the board's evidence and why you did not believe the respondent's evidence. And that simply didn't happen. There isn't, as I said before, a single cite in those credibility determinations. They also have, there is not a single cite to the expert witness testimony and the difference between the expert witness testimony. The expert witness for the defendant, respondent, was the chief of emergency medicine at Northwestern Memorial Hospital in Chicago. He was on the stand for a day, and there's not a mention of his name in the original finding. It is mentioned in the credibility findings. It is mentioned. But the substantial evidence rule was simply ignored. The administrative magistrate made up her mind, made a number of findings of fact, and didn't do her job, is what it comes down to. Did not cite to the record, because if she had cited to the record, her findings would not have stood. I included in the motion for, renewed motion for judgment on the pleadings, 20 pages of itemized instances where her findings are not supported in the record. And I'm not going to go into, unless you want to, those 4 cases and the medicine involved. The medicine is not that difficult to understand. It's sort of basic ER medicine. But when somebody comes in and says, no, I do not believe it was medical malpractice and not below the standard of care, and that testimony is simply ignored, you've got something wrong. You have a systemic problem. Because if this is the case, then we might as well not have a DALA hearing. Why put on a case if your testimony and evidence is going to be ignored? Then we get to the issue of the severity of the sanction. And we're well aware of the precedent of this court that it will not step in and overturn the determination or the sanction imposed by an agency except in very rare circumstances. Well, I think we have the rare circumstances here. You have an individual, and we're referring specifically to the Arthur's case. He has not had a complaint about his practice since the year 2000. 3 of the complaints that formed the basis of the board's statement of allegations occurred in 1997. Since all this started, and in the very rare occasion where he gets to work a shift in an ER, his evaluations by the different ER supervisors have all been that he is meeting or exceeding the standard of care. But here's the point of the whole case. If the suspension stays in place, he can never practice medicine again, because the regulations of Medicaid, also known as Mass Health, say if you've ever had your license suspended, you can't participate as a provider in the Medicaid program. Now, there are certain kinds of physicians who don't see that many Medicaid patients, but this gentleman sees patients in Holyoke and Springfield, and most of the patients that he sees, something on the order of 2/3 to 3/4 of the patients that he sees are Medicaid patients. So he's unhireable, because even though people would want him on their staff to render care, he can't bill. And there are not only state law implications, but there are federal law implications, where the feds could come in and close down the hospital if they knowingly employed an individual who had once had his license suspended. So, and if that matter had been resolved, and we tried to resolve it for years, literally for years in front of the board, nope, it's going to be a suspension. And that
Does that apply no matter what the duration of the suspension?
That's true. Exactly. The language is embedded in my mind, which says if you have ever had your license suspended, and then there are another revoked other verbs in there, you cannot participate as a provider in this system.
Mr. Dunn, you have asked for a dismissal of the proceedings. Are you suggesting that no sanction is warranted in these circumstances?
I'd have to go that far and say yes, and the reason is the timeline. 1997, 10 years. There's a difference of opinion, and there will always be a difference of opinion if you tried this case over and over again between medical experts on this case. He's never had a malpractice suit filed against him. So we're not talking about a bad or substandard physician who we're trying to keep from the inevitability of non-practice. We're saying he has a right under Arthur's to not have his ability to practice medicine taken without due process of law, and he hasn't received it. Now, this is very close, Your Honor, to Herridge. Very, very close to Herridge. In Herridge 1, the single justice sent the case back down to the board. The board did not do its job a second time, and Chief Justice said if they've ever had a chance to correct this situation, the situation is no longer correctable, and he dismissed the underlying complaint against Dr. Herridge. And that's basically the only way out, because otherwise anybody who is licensed is going to be looking at a 30A, which is toothless and cannot be relied upon. They've proven, both Dalla and the board has proven, they cannot handle this case in a way consistent with the statutes that were cited. So we are asking that we dismiss the underlying complaint, vacate the final decision and order, or otherwise, as I've said before, this physician can never practice again.
Thank you, Mr. Dunn.
Thank you.
Ms. Weiss.
Thank you, Your Honor. Juliana Rice, Assistant Attorney General for the Board of Registration in Medicine. First, I'd like to point out that Dr. Birudavol has never, until this morning, made the argument that he will never be able to practice again in the future. He's only made the argument that his current practice is restricted due to the ongoing nature of the board suspension and probation agreement.
Well, I mean, are you saying we can't take notice of the fact? Do you dispute that if ever suspended, he can't deliver medicine to patients who are covered by Mass Health?
I don't know that to be the case at all, Your Honor. It's never been briefed before this Court. It's never been raised to the Board.
Well, shouldn't the Board know that? Doesn't the Board know what the implications of its sanctions is?
The Board may well know that, Your Honor, but I don't know that because...
Well, you're the counsel to the Board.
I am counsel to the Board, but, Your Honor, the issue has never been raised. It's never been argued. It's never been briefed. I certainly can submit authority to this Court, but Dr. Birudavol has never sought to vacate his suspension on the ground that he will never be able to practice again. In fact, as Mr. Dunn states, he continues to practice even to date under a probationary agreement put in place by the Board.
Well, that's different. I mean, until you get this thing resolved, correct? I mean, the sanction is not final at the present time, is it?
No, Your Honor. That were earlier proceedings, however, against, where I was not counsel, but against the division then known as the Division of Medical Assistance that administers the Medicaid program known in Massachusetts as Mass Health, where Dr. Birudavol had sought to obtain a temporary restraining order barring that division from removing him from the Mass Health roles. That, in fact, that temporary restraining order was denied, and there's no stay in place. There's nothing in the record to reflect that there's a stay in place, and my understanding is that the Mass Health program did, in fact, remove Dr. Birudavol from its roles, and he would remain unreimbursable pending his suspension and or probationary agreement, which has been in place for part of these proceedings and not for other parts. And there's nothing in the record reflecting whether it is currently in place. Notwithstanding the Medicaid issue, which should not be determinative of this case, given the overwhelming evidence of continued instances of substandard care in 2 different emergency departments rendered by Dr. Birudavol, his arguments concerning the insufficiency of the credibility determinations and the initial recommended decision should be rejected by this Court. It is true that the single justice did remand this case once because of the failure of the administrative magistrate to treat and dispose of some conflicting expert testimony. That deficiency was fully rectified on remand. Dr. Birudavol never again, until this morning, argued that the Board was acting outside its authority or contrary to the order of Justice Cordy when it remanded the case to the administrative magistrate for further findings concerning her credibility determinations. Those determinations included in the March 6th supplemental administrative record from pages 3 to 8 and presented to the single justice make very clear that the administrative magistrate specifically considered the evidence of both expert witnesses, and to the extent they diverged, she made very clear her reasons for accepting one over the other. And this is important. Dr. Birudavol argues today that there is just a difference in medical expert testimony. In fact, there is no difference in the most important, the most serious of the 4 cases with regard to patient A. Dr. Birudavol's own expert agreed with the expert of the Board prosecution that, in fact, Dr. Birudavol's care was substandard. And Dr. Birudavol's own expert indicated his recommendation that Dr. Birudavol undergo a course of continuing medical education in the cardiac area, just as his physicians group had imposed that he had rejected, and to date he has still not done that. With regard to patient A, the credibility determinations make very clear that the administrative magistrate credited multiple eyewitnesses to the incident, the testimony of 3 nurses who were present that night, as well as contemporaneous notes of the incident prepared by 1 nurse, that Dr. Birudavol refused, without good reason, to see patient A, who was in acute distress with chest pain, without a chart being made up. The administrative magistrate also discounted Dr. Birudavol's testimony and found it evasive and untruthful, that patient A was comfortable, even though reports were consistent that patient A was reporting chest pain 10 out of 10, was sweating, bluish in color, and incontinent. And again, Dr. Birudavol's own expert admitted that facets of Dr. Birudavol's care of patient A were in fact substandard. With regard to patient B, the administrative magistrate specified that she was rejecting Dr. Birudavol's expert testimony because it was internally inconsistent. The expert, Dr. Matthews, acknowledged that the note of the examination that Dr. Birudavol had conducted of patient A's abdomen was in fact unacceptable, but still found that there was no deviation from the standard of care. With regard to patient C, the administrative magistrate accepted the board's prosecution expert's testimony that an EKG should have been done on patient C upon her arrival in the emergency room at around midnight after falling at home. That the purpose of an EKG in this case would be to check for a cardiac arrhythmia that could have caused patient C's fall and might also cause the stroke that she ended up experiencing in the emergency department. That prompt treatment of that arrhythmia might have prevented that stroke. The evidence also established to the administrative magistrate's satisfaction, and that finding is not challenged here, that patient C was not put on a cardiac monitor until 3 hours after arriving in the emergency department. If true, even Dr. Birudavol's own expert would state that the standard of care had been breached here. And again, he does not challenge that underlying finding as clearly erroneous or unsupported by substantial evidence. Finally, with regard to patient D, the credibility determinations make clear that the administrative magistrate accepted the board prosecution expert's opinion that IV fluids and cardiac monitoring should have been started upon patient D's arrival in the emergency room around noon. And the evidence, in fact, established that they were not started until around 4 p.m. after Dr. Mullen, who was covering for patient D's regular physician, appeared in the emergency room and took over patient D's care.
Ms. Slice, may I just ask you something about the timing of this? The last patient involved here, patient D, the episode appeared on March the 13th, 2000, correct?
In March of 2000, correct.
And then the statement of allegations is 3 years later.
That's correct, Your Honor.
What accounts for this lengthy delay?
Investigation by the board investigatory staff. There's nothing in the record to reflect when, in fact, the complaints were made to the board. Complaints made to hospital administration are contained in the record. One can infer that it wouldn't have been too terribly long. But this court, in the Ingalls case in 2005, looked at a very similar timeline, 3 years for investigation and the issuance of a statement of allegations, and declared that there was no problem with that.
Well, I have to say it's of some concern that we're now 10 years down the road from the first ones.
Correct, Your Honor. 3 of those years have been involved in judicial review proceedings, or almost 3 of those years. And I'll also state that there was a motion to dismiss brought by Dr. Birudavol before the administrative magistrate, and that proceedings on that appear in the January 2005 administrative record. Starting on page 79 is the denial of that motion to dismiss, specifically finding that there was no prejudice from any delay to Dr. Birudavol because he knew of the complaints and all records were available. And in fact, the board's own regulations on staleness did not apply because of the closeness in time between the events that took place and the complaints that were made, which were, again, within a few days in all 4 cases. 2 complaints were made by other medical personnel, 1 incident report, and 2 complaints were made by the patient B and the family of patient C. On your review of...
Do you know when the case was first filed in the single justice session?
Yes, Your Honor. The first board decision was in July of 2004, and within 30 days, the complaint for judicial review was commenced in the single justice session. In October of 2005, the first board decision was vacated, and the remand and the credibility determinations followed. The second board decision that's before the court today was issued January 18th, 2006, and was affirmed by the single justice in June of 2006. There was some further delay when the case first came up to this court because Dr. Birudavol had filed it as, or it somehow became classified as a Rule 221 appeal from an interlocutory determination, although in fact there was no interlocutory determination here. If the court has no further questions, I will simply ask that the decision and the decision of the single justice be affirmed.
Thank you, Ms.
Thank you.
Slice.